Welcome to IR Insights Australia, brought to you by Dentons. IR Insights, hosted and featuring members of our National Employment and Safety team and guests, delivers practical guidance and expert analysis on employment law and workplace relations in Australia. This series is designed to help employers stay informed and compliant in a rapidly changing regulatory environment, as well as provide practical strategies to help you manage workforce challenges with confidence. We invite you to send any questions to our dedicated email, irinsights.au@dentons.com. Before we begin, we'd like to share an acknowledgement of country from Auntie Munya Andrews.
Nangamalari, I'm Auntie Manya, and on behalf of Dentons and everyone here today, I would like to recognise the stories, traditions, and living cultures of the land on which we meet. We acknowledge the traditional custodians of this land and their continued connections to land, sea, and community. And we pay our respects to elders past and present. Nangamalari.
Welcome everyone, and thank you for joining this IR Insight session, Payroll Under Pressure Compliance Essentials. My name is Helen Lee and I'm a partner in the Employment and Safety team at Dentons in Melbourne, and I'm joined by Angela Cartwright, Senior Associate in our team in Sydney. How are you, Angela?
Well, thanks, Helen.
That's great. With ongoing regulator activity, new case law and reforms, and significant penalties for non-compliance, managing payroll has never been more complex. So in this session, we're going to contextualise our discussion by providing an overview of the regulatory and industrial landscape, explain the potential impacts of accessorial liability, including for anyone involved in an HR, payroll, finance, or management role, so a broad list of roles there. Unpack some of the common causes of underpayments that we have seen on the matters we've worked on, discuss payroll controls and governance, consider what employers can learn from the cases, and finish with key takeaways and a practical compliance checklist. If you have any questions, please do not hesitate to contact us by phone or email after you have listened to this session. All right, we'll get into the regulatory and industrial landscape. The first major consideration is ongoing activity by the Fair Work Ombudsman. Pay compliance continues to be a key focus area for the Ombudsman, and during the 2022 to 2024 financial years, the Ombudsman recovered $1.5 billion in back payments to workers. In the 2025 financial year alone, the Ombudsman received over 25,000 anonymous complaints, issued over 1,200 compliance notices and over 700 infringement notices, initiated 73 separate court proceedings, including securing a court-ordered penalty of $15.3 million against one employer for deliberately underpaying employees, and entered into 8 enforceable undertakings, 4 of which were with universities, a key focus area for the Ombudsman. The Payroll Remediation Program Guide, published by the Ombudsman in April last year, recognises that employers increasingly need support in remediating inadvertent payroll errors. In our experience, payroll errors are very common, including due to the complexity of the industrial instruments that apply, and that can even be the case where it's an enterprise agreement that has been negotiated by the employer. As I said before, one of the key priority areas for the Ombudsman is the tertiary sector, but its other priority areas are very broad-based and include aged care services, agriculture, building and construction, disability support services, fast food, restaurant and cafes, and all large corporates. So it captures a wide range of employer organisations. Any employer that underpays an employee, even unintentionally, is at risk of civil penalties under the Fair Work Act civil penalty regime. Substantial penalties apply for non-compliance with the Fair Work Act, up to $4.95 million per contravention in the most serious of cases. And a serious contravention is one that includes where a person is knowing or reckless in respect of non-compliance. The Ombudsman is also continuing to target accessories involved in contraventions. Under the accessorial liability provisions of the Fair Work Act, any individual who is involved in a contravention may be held personally liable as an accessory in order to make payment of unpaid wages, other entitlements and penalties. And we'll explore accessorial liability in more detail later in this session. The second area is wage theft and the new wage theft provisions set out in the Fair Work Act. So since 1 January 2025, it has been a criminal offence for an employer to intentionally engage in conduct that results in a failure to pay certain employee entitlements. Individuals can also be prosecuted under the related offence provisions. So an employer may commit a criminal offence, under these provisions where they were required to pay an amount to an employee or on behalf of the employee or for their benefit, and have intentionally done something that intentionally results in those amounts not being paid on or before they were due. The Ombudsman has set up a criminal investigations branch and can refer matters to the Commonwealth Director of Public Prosecutions or the Australian Federal Police for potential criminal prosecution. And prosecution can result in monetary fines, imprisonment, or both. The next area is payday super, which is an important reform. From 1 January 2026, employers must pay employee super contributions at the same time they pay their salary or wages, so that the contributions reach the employee's nominated superannuation fund within 7 business days. This is one of the most significant payroll reforms of the decade, requiring real-time superannuation processing, system changes and consideration of the impact on cash flow availability for organisations who, prior to this change, many of which were making payments at the end of each quarter. So to avoid the imposition of a super guarantee charge, super guarantee contributions at 12% of an employee's qualifying earnings must be paid to an employee super fund on payday and received by that fund within 7 business days, unless there's an extended time period, such as for new employees. So ahead of 1 July, all employers need to review their payroll systems and business processes to make sure they are ready for payday super. Late payment of super may be a contravention of the Fair Work Act or a particular industrial instrument. And where super is not paid on time, current and former company directors may be held personally liable for the unpaid super guarantee charge liabilities. The next matter is the Federal Court decision in Fair Work Ombudsman and Woolworths Group Limited and Coles Supermarkets Australia. It's a decision that employers are continuing to grapple with. It has provided some clarification on annualised salary arrangements, the use of set-off clauses in contracts of employment, and record-keeping obligations for award-covered employees, including the level of detail required in those records, which is greater than previously thought to be the case. The case is currently listed as adjourned for review of progress. A further case management conference in relation to the proposed declarations and remaining issues for determination was listed for the day that we're recording this webinar, 23 March, and the orders are not yet available. Once the matter has been finalised, an appeal may be lodged because of the significance of the decision. As it currently stands, the decision has implications for any employer with award-covered employees on an annualised salary arrangement. In this matter, the employees were covered by the General Retail Industry Award and were all employed under written contracts providing for an annual salary. The court held that compliance in respect of every pay period is required, so underpayments in one pay period cannot be offset by overpayments in another pay period. As a result, set-off clauses in existing contracts of employment will require careful review if that's not already been done, including to ensure that there is an obligation to make payment and that the offset applies to the particular pay period, whether that is weekly, fortnightly, or monthly. The court also held that where an employee agrees to vary an award entitlement, such as the duration of a break between shifts, the objective circumstances must show that the employee was aware of the entitlement and agreed to vary it. The employer has the onus of proving that an agreement was reached. So simply having an employee attend for work in accordance with a roster is not sufficient evidence of consent and agreement to that change. In respect of record keeping, the court held that compliance needs to be evidenced at the time work is performed and paid, and records must be readily available and not require interpretation by an inspector, such as reconciling two separate records that don't talk to each other. Essentially, the employee needs to be given enough information for them to understand why a particular rate is being paid and how that payment has been calculated for them. Where records are not held or where there are only partial records, the burden of proof will shift and the employer is required to disprove any allegation against it. So that might be an allegation in relation to underpayment, rather than the Ombudsman having the burden of proof of proving that allegation against the employer. So this decision, although not yet resolved or completed, has prompted many employers to seek assistance with reviewing and updating their contracts of employment and their record-keeping arrangements. All of these factors highlight the importance of employers reviewing and embedding payroll compliance across their organisations. Another factor also to keep in mind is that organisations that deal with third parties are increasingly requiring assurance and confirmation that those third parties are compliant with their obligations under workplace laws as a condition precedent to doing business with them. So this may arise in a contracting scenario or pursuant to insourcing or outsourcing arrangements. And this, of course, obviously increases the impetus to proactively address payroll compliance. I'm now going to hand over to Angela, who's going to talk to us about accessorial liability. Thanks, Angela.
Thank you, Helen. So when pursuing remedies for underpayment contraventions, it's become increasingly common for the Ombudsman to pursue the individuals involved, not just the employing entity. So what is accessorial liability? Well, under Section 550 of the Fair Work Act, any person who is involved in a contravention of a civil remedy provision is taken to have contravened that provision. This means the breach is attributed to that person. So a person is considered to be involved in a contravention if they aided, abetted, counselled or procured the contravention, induced the contravention, whether by threats or promises or otherwise, were in any way by act or omission, directly or indirectly, knowingly concerned in or party to the contravention, or conspired with others to effect the contravention. This means to be an accessory, a person must have had essential knowledge of those essential facts of the contravention, been knowingly concerned in it, and participated in it, based on actual knowledge of the essential facts or willful blindness. A person actually does not need to know that the facts constituted a contravention or offence, they just need to know the facts themselves. The Fair Work Act also contains some specific provisions that were introduced in 2017 under the Fair Work Amendment Protecting Vulnerable Workers Act. So the Vulnerable Workers Amendments included new provisions impacting certain franchisors and holding companies, under which they can be held responsible if their franchisees or subsidiaries contravene workplace laws. This is the case if they knew or should have known and could have prevented the contraventions. Those vulnerable workers provisions are similar to the general accessorial liability provisions, but they only apply to franchisors that have a significant amount of influence or control over the business affairs of their franchisees. Franchisors must take reasonable steps to prevent breaches of workplace laws across their network. The Ombudsman can commence proceedings against an accessory under the vulnerable workers provisions, so that includes Section 558B of the Fair Work Act, or under the broader general accessorial liability provision in Section 550 of the Fair Work Act. Under Section 550, an accessory can be an individual or a body corporate. The knowledge of an officer, employee, or agent is attributed to the body corporate. Willful blindness, where a person has deliberately shut their eyes to what was going on or has failed to make inquiries, is sufficient to constitute actual knowledge of a contravention. Where a person's involved in and has actual knowledge of a system of non-compliance, proof of actual knowledge of each single instance of non-compliance isn't necessary. Some examples of persons who may be found to be involved in a contravention include senior managers and directors, line managers, payroll officers, and HR professionals, internal and external advisors, such as accountants, lawyers, and payroll service providers, head contractors and franchisors in respect of their subcontractors or franchisees, labour hire providers or host companies, and unions and union officials. This slide here includes details of the number of decisions of courts, as opposed to tribunals such as Industrial Relations Commissions or the Fair Work Commission. So the court decisions that are visible on osli.edu.au. In particular, all decisions that have considered or referred to Section 550 of the Fair Work Act, as at 26 February 2026. So this doesn't have regard to whether those decisions gave material consideration to Section 550, but it does demonstrate a noticeable upwards trend in cases that refer to accessorial liability. The Ombudsman's litigation policy emphasises that one of the key purposes of litigation is that it makes the need to comply with workplace laws real for individuals, and that even in circumstances where breaches have been fixed, it may still be appropriate for the Ombudsman to commence legal proceedings, including against any person who was involved in a breach. In contrast to the high number of cases involving accessorial liability under Section 550, as we see here, there are only a handful of cases that have been brought using the specific vulnerable workers provision for holding companies and franchisors. So most notably in 2025 against Baker's Delight Holdings and Retail Food Group Limited, in 2024 against 85 Degrees Coffee Australia, in 2023 against McDonald's Australia, and in 2020 against United Petroleum. The broader scope of the accessorial liability provisions under Section 550 means that it's an easier avenue to hold related companies directly liable. On this slide, we've got some examples of some of the types of contraventions for which accessories may be held personally liable. Importantly, this includes contraventions of the National Employment Standards, contraventions of modern awards or enterprise agreements, underpayments, record-keeping failures, and unlawful deductions. The Fair Work Act allows eligible courts to make a wide range of orders where a person is found to have breached the Act. For example, potential consequences could include penalties, injunctions, orders to pay compensation, orders to rectify underpayments and pay interest, and orders to conduct a wage audit or implement training. There are a range of other possible consequences where a person or employer is involved in a contravention, such as reputational damage and the inability to tender for work. In some cases, the Ombudsman has successfully obtained orders for penalties to be paid via regular deductions from an individual's pay, such as deductions from a former company director's pay. Not all matters investigated by the Ombudsman will result in litigation being commenced. The Ombudsman has a range of other compliance tools it can use, such as enforceable undertakings and compliance notices. Employers need to be able to identify the root causes of underpayments and any other payroll errors in order to be able to address them. Underpayments are a significant issue for employers of all sizes, from small businesses to large organisations. So here we have set out some of the common causes of underpayments. First one is around industrial instruments. So misclassifying employees and misunderstanding or misapplying entitlements under modern awards or enterprise agreements is one of the biggest risks to employers. Employers are juggling the application of potentially multiple instruments, including modern awards or enterprise agreements. There's added difficulties in managing payments to employees for flexible, hybrid, and shift-based work or variable work patterns. Another key risk is changes in laws and entitlements. Employers risk significant underpayment issues where they fail to keep up to date with changes to the Fair Work Act and modern awards, including changes in rates of pay and entitlements from 1 July each year. Next, in terms of data and systemic payroll errors, inaccurate or non-existent time and attendance data is a major gap for many organisations. For example, relying solely on rosters or having manual processes for entering leave or receiving overtime pay or allowances are a major source of compliance risk. Systemic payroll errors can arise from the use of outdated or misconfigured payroll software and can often go undetected for long periods of time until an audit is done or an employee raises a concern. Next, we have inadequate record keeping, so failing to maintain records in sufficient detail in a form that complies with the Fair Work regulations is another major risk. Similarly, issuing incorrect or incomplete payslips or not issuing payslips at all contravenes the Fair Work Act. Importantly, the recent federal court case involving Coles and Woolworths suggests that relying solely on rosters or clock in and clock out data does not satisfy the record-keeping obligations, as Helen mentioned earlier. Records must be readily accessible to an inspector and must include the specific details of an employee's entitlements, not just raw data that would require interpretation or inference. Employers must have systems that accurately record the specific pay entitlements for each employee, not merely their hours worked. Underlying each of these other causes of underpayments, a common thread is failure to ensure appropriate resourcing for an employer's legal, HR, and payroll functions, and low levels of communication between different parts of an organisation that ideally should be working together for the purpose of achieving payroll compliance. Where organisations adopt a siloed approach, the risk of inadequate oversight and lack of communication leading to payroll errors significantly increases. The Ombudsman will seek evidence of whether an organisation demonstrates governance maturity and proactive compliance, or is mainly reactive, addressing issues only after they arise and without future-proofing their governance arrangements and making system improvements. Employers need documentary evidence to support the selection and integration of their payroll system, ensuring that it's sophisticated enough to be fit for purpose based on the size and complexity of their business operations. System-enforced rules should be set up correctly, with approvals needed for any manual overrides. Employers must capture detailed time and attendance data. SDP2 reporting means that regulators receive granular per-employee payroll data. The Ombudsman expects compliance in respect of every payment to every employee in every pay period. There must be processes in place to ensure two-way communication between payroll and HR if they're separate teams. Payroll is complex and difficult to get right without HR support, including because it sits at the intersection of employment, tax, and superannuation laws. There's an increasing emphasis on real-time reporting and automated cross-matching of data by the regulators. Where an organisation takes a siloed approach and different departments don't talk to one another, the level of risk increases. A review of record keeping and payslip obligations should be undertaken in light of the Coles and Woolworths decision. There's a higher onus to have records that are readily accessible and do not require interpretation by an inspector. Payroll and HR teams need proactive governance frameworks, technology that reduces the risk of manual errors, and ongoing compliance training to meet their obligations. There should be frameworks to address matters such as award or enterprise agreement classification and interpretation, identification of each separate entitlement paid to employees, such as overtime, penalty rates, and allowances, the accuracy of accrual and payment for leave entitlements, including annual leave, personal leave, long service leave, and any paid parental leave, tax withholding accuracy, including seeking specialist tax advice where required, superannuation compliance, including payday super readiness, and, as mentioned previously, record keeping and payslip compliance. Regular internal or external payroll reviews or audits are now expected by regulators, particularly for large organisations or for any organisation with a history of non-compliance. Payroll reviews should include reviewing and reconciling employees' actual working hours against their entitlements under the applicable award or enterprise agreement. This will assist in identifying any potential shortfalls early and then allowing them to be rectified as soon as possible. Payroll sampling is a good way to identify any potential underpayment issues. Management and executive ownership of wage compliance is also critical. It should be a standing board agenda item with ongoing internal reviews and exceptions reporting to detect any issues early. We also recommend providing multiple avenues for an employee to raise any concerns that they have regarding underpayment. It's critical to have robust internal controls and governance frameworks in place to reduce the risk of potential underpayments, penalties, and reputational damage. I'll now hand over to Helen to talk us through some case studies.
Thanks, Angela. That was a really good overview of the governance controls that are required. We're now going to look at some case studies and discuss what employers can learn from those examples. And really, these examples reinforce the need for regular payroll reviews rather than a set and forget approach. So our first example is the enforceable undertaking that the University of Tasmania entered into with the Fair Work Ombudsman in December 2025. This undertaking requires the university to make over $21.4 million in payments, including interest and superannuation, to more than 10,000 employees who are underpaid across a period of 11 years at the university. Most of the underpaid employees were casual, professional, and academic staff, though some were full-time and part-time employees. The underpayments were largely due to three key reasons. The first, failing to pay casual professional staff for a minimum engagement period of at least 3 hours per shift, as was required under the university's enterprise agreement. Employees being underpaid the penalty rates that they were entitled to be paid for shift work. And finally, employees being paid incorrect rates of pay. In considering the matter, the Ombudsman said that the key causes of the widespread underpayments were the university's poor governance processes and fundamental payroll system deficiencies. The university became aware of its underpayment when it conducted a self-initiated review and then it self-reported its non-compliance to the Ombudsman in 2021. The back payments to impacted individual employees range from $6 to more than $280,000, including super and interest. Under the enforceable undertaking, the university is also required to make a contrition payment of $175,000 and implement a broad range of measures to ensure compliance with workplace laws in the future, including completing the secondary phase of its remediation program, providing the Ombudsman with information about the systems and process improvements it is intending to implement to ensure future compliance, ensuring relevant staff complete additional training regarding their obligations under the Fair Work Act, commissioning 2 compliance audits to check that the university is meeting all employee entitlements and rectifying any underpayments that may be found, informing staff of the enforceable undertaking through all staff emails or written notices to affected employees, maintaining a separate employee payments complaint and review mechanism, and prioritising and embedding within its audit and risk committee the monitoring of compliance with Fair Work instruments. In its media release at the time the enforceable undertaking was entered, the Fair Work Ombudsman Anna Booth said that this matter serves as a warning of the significant long-running problems that can result from an employer failing to have appropriate checks and balances to ensure workplace compliance. Our next case study is the Sushi Bay matter. In 2024, the Ombudsman secured penalties of $15.3 million against the former operators of the Sushi Bay restaurant chain outlets for exploiting vulnerable migrant workers, including underpaying workers more than $650,000 over a 4-year period. The penalties imposed included $13.7 million across 4 related companies and $1.6 million against Miss Shin, who was the owner and sole director of the companies involved. The underpayments affected 163 employees on student, working holiday and skilled visas. And like the University of Tasmania matter, the underpayments range from $48 to $84,000. The deliberate and systematic nature of the conduct meant that some of the breaches were serious contraventions within the meaning of the Protecting Vulnerable Workers laws that Angela mentioned earlier, attracting up to 10 times the maximum penalties that would ordinarily apply. Most of the underpayments in this matter related to the failure to pay adequate overtime rates. Workers were paid flat cash rates of between $14 and $18.50 an hour for some overtime worked, despite being entitled to payment rates of between $25.94 and $48.24 an hour under the Restaurant Industry Award. Minimum wage rates, weekend and public holiday penalty rates, and annual leave entitlements were also underpaid, and the employer knowingly made false or misleading records and provided them to the Ombudsman. 20 employees who were visa holders were also subjected to an unlawful cashback arrangement under which they were at times required to pay back hundreds of dollars from their fortnightly wages to the employer. In handing down its decision, the federal court said the penalties must make it clear to Ms. Shin and other people and companies who employ staff that contraventions of this kind are both unacceptable and economically irrational. The court also recommended that information that was available to it in the litigation of this matter be shared with other regulators. Now I'm going to hand over to Angela again, who's going to take us through the third and fourth case study.
Thank you, Helen. So our third case study is the 2024 case involving the Din Tai Fung restaurant chain. In this case, the Ombudsman secured around $4 million in court-ordered penalties against the former restaurant operators for deliberately and systematically underpaying vulnerable migrant workers and creating false records. Penalties included $3.88 million against the two entities that employed workers in Sydney and Melbourne, plus over $90,000 against the former general manager, Ms. Handoko, and over $105,000 against the former HR coordinator, Ms. Parmenas. Allegations were also made against Mr. Hayanto, director of both employing entities, but the proceeding against him was discontinued when the Ombudsman was unable to serve him with the initiating process. The court found that the companies and their senior management had committed multiple breaches of the Fair Work Act, including some serious contraventions, committed knowingly and systematically. 17 employees had been deliberately underpaid a total of over $157,000 under the Restaurant Industry Award, and the management team kept and provided false records to Fair Work inspectors. The false records generally understated hours worked and included false rates of pay for casual employees. The affected workers were mainly visa holders on student or employer-sponsored visas and engaged in casual roles. The flat hourly rates paid to the casual employees and the fortnightly salaries paid to the full-time employees did not meet various award entitlements, including minimum rates for ordinary hours, penalty rates for weekend, public holiday and evening hours, split shift allowances, overtime rates, and casual loading. Some workers were also requested or required to work unreasonable additional hours. The false records and the underpayments were held to be deliberate and systematic conduct. The Ombudsman investigated after receiving a request for assistance from an affected worker. In its decision, the court found that the general manager and the HR coordinator were involved in setting the unlawful pay rates, and that the HR coordinator knew from the time she started working for the DTF group or shortly thereafter that the pay slips and records were false or misleading. Commenting on the case, the Ombudsman said, "Lawful minimum rates apply to all employees in Australia, and they are not negotiable. All workers in Australia have the same rights, regardless of nationality and visa status." When comparing the Din Tai Fung case to the Sushi Bay case, the total quantum of underpayments in Sushi Bay was around 4 times higher, and the total penalties were correspondingly also around 4 times higher. Both of these cases demonstrate the seriousness of record keeping and underpayment contraventions and the court's willingness to impose significant penalties. Our final case study is one in which the Ombudsman secured close to $400,000 in penalties against Polytrade and its owners. Polytrade was one of the largest recycling companies in Victoria at the time. The federal court found that 5 vulnerable migrant workers had been underpaid close to $200,000 for their work at waste management facilities in Melbourne. The Ombudsman investigated after receiving a referral from the Australian Workers' Union. The 5 affected workers were on protection visas and bridging visas after arriving in Australia as refugees. The federal court imposed penalties of over $200,000 against Polytrade Employment Services for directly underpaying the workers. This entity had been set up as a labour provider, employing workers and supplying them to work at Polytrade on an on-hire basis. Penalties of over $138,000 were imposed on Polytrade for being an accessory in the underpayment. There are also penalties of over $27,000 and $8,000 respectively imposed against Polytrade's owners, Mr. Chen and Ms. Ho, for also being accessories. Fair Work inspectors discovered that the 5 affected employees were paid a flat rate of $22 per hour, regardless of when they performed work, despite being required to perform night, weekend, and public holiday work. Some of the workers gave evidence in court that they worked 12-hour shifts, usually 6 and sometimes 7 days per week. This resulted in underpayment of their minimum wage rate, overtime rates, loadings for casual night and shift work, and penalty rates for weekend and public holiday work under the Waste Management Award. Laws relating to minimum engagement periods, advising employees of their terms of engagement, payment of superannuation entitlements, record keeping, and issuing pay slips in the required form were also breached. Ms. Ho was involved in each of the contraventions in that as the Chief Financial Officer, she either processed and approved the payroll in the ways that led to the employees not receiving what they were entitled to under the award, or otherwise failed or omitted to ensure that the employing entity complied with its legal obligations under the Fair Work Act. The 5 underpaid workers were back paid in full, and a further $2.2 million in back payments were made to workers not involved in the Ombudsman's legal action. At the time, the court said the employer's conduct was wantonly naive at best. At worst, it involved a deliberate and cavalier disregard of important award safety net obligations. Therefore, Justice Snedden held the court must exact a heavy toll to serve as a warning to other employers who might be minded to ignore their own important award and statutory obligations. Helen will now talk us through the key takeaways.
Thanks, Angela. So what are the key takeaways? When setting up a payroll function, employers must embed compliance from the outset, which includes checking pay code configurations and completing pre-implementation sample testing for any new payroll software or payroll processes so that any errors are identified early. Encourage employers to seek advice where required. For example, if you're unsure about the application or interpretation of a modern award or enterprise agreement, or if you identify a potential payroll issue, better to address it early than let it fester and grow. Employers commonly need to seek advice on matters such as employee classification and progression, any pay rates and entitlements under industrial instruments. And when tightening the classification and onboarding process, it's also a good time to check whether your employment contracts are compliant with any modern award obligations. We also recommend conducting regular payroll reviews, including payroll sampling at least annually. The risks of potential non-compliance can be mitigated through proactive payroll reviews, and payroll sampling is essential to assess your compliance with the record keeping and payment obligations under both the Fair Work Act and Fair Work regulations. It's critical to stay up to date with changes in the law, such as the changes in modern award rates on 1 July each year, other changes that are occasionally made to awards by the Fair Work Commission, major reforms such as the payday super reforms that will take effect on 1 July this year, and ad hoc developments through the courts as decisions are handed down, as we've seen in the Fair Work Ombudsman Coles and Woolworths decision. The Fair Work Ombudsman is a very active regulator. Accurate and compliant systems, governance frameworks, and proactive monitoring are essential to meeting employers' obligations. Employers must take these practical steps to ensure employees are paid correctly. As Angela said, every employee, every pay period, every payment. Payroll is no longer just an operational or administrative function, it is a high-risk compliance work. Payroll compliance is both a legal requirement and critical to maintaining trust with employees. So finally, thank you for joining us for this episode of IR Insights. If you have any questions on what we've discussed today, please reach out and we'll be very happy to assist you. Thank you for listening.
Missed an episode? You can catch previous episodes on our website and as a podcast on Apple and Spotify.